safe and at home. And our water rights system, you can kind of think of it that way too, where we have our seniority rank is one of those core components of insulating your right from the outside world. But when the outside world comes and gets in your way, you need something to stop it. And we have a problem in Washington State where ecology is not managing and enforcing the water rights that's wholly underneath its jurisdiction, and there is some harm being caused to the senior rights holders. And in particular, there is some harm being caused to Lummi. And so when we look at the facts, we have Lummi sits in the Nooksack Basin with a Federal Reserve Indian water right with a priority date of time immemorial. Now, where does that priority date come from? It comes from the fact that it's linked to a treaty. And the treaty was not the beginning of the Lummi tribe. The treaty was the beginning of a formal relationship between Lummi and the United States. So in Indian law, we recognize that tribes have existed since time immemorial as sovereign independent governments. And so those rights that the tribes retained when they entered into a treaty also have existed since time immemorial. And because Washington didn't become a state until 1889, kind of our chronological knowledge tells us that time immemorial is more senior than 1889. So we have a priority date that needs to be insulated from protection, insulated from harm. So what has been done to create that protection is that Lummi and other governments have spent over 1 decade, that's over 10 years, attempting to reach settlement to stop the harm to the most senior water rights while attempting to balance other interests. I'm just curious, in other relationships in people's lives, have you spent 10 years to work out an agreement on anything? I mean, it's a profoundly long time to sit at a table and to come back with new ideas and different approaches and potential ways to see things. So what I'm talking about is Lummi's desire to move past that 10 years of conversation. And that's why Lummi is seeking the litigation to protect this reserved Indian water right. So the settlement efforts did dissolve. I don't think there's really any heartache over the fact that they dissolved. I mean, I see Doug around town, I say hi to him. I see folks from the city of Bellingham around town, I say hi to them. And we all sat at the table and did negotiations together, and it just didn't work out. So in 2011, Lummi took the next step by seeking litigation by the United States against Washington State, pursuant to that trust relationship that I spoke about, for the express purpose of quantifying and then protecting the most senior water right in our basin for purposes of in-stream flow. And some people will ask, what is Lummi's goal through doing this? You know, is Lummi being antagonistic? Is Lummi looking to take away value from Whatcom County lifestyles and industries or anything like that? And I think those are all questions that are loaded with values that come from other folks. So I'm just going to be very clear about what Lummi's goals are, and this comes directly from the council that they're my client at Lummi. It's to get a quantification for the reserve water right for in-stream flows, to protect the treaty-protected fishery and the right to go get fish. And then certainty is another thing that Lummi's really after. What is the value, what is the amount of the right, what is the amount of water that remains in the stream that will be protected in times of water shortage? Or put conversely, where will Lummi get the protection that every other water user in the state of Washington is entitled to, and that is protection from junior infringement on your most senior water right? Right now, Lummi doesn't have any of that protection. There's no protection for the most senior water user in our basin because we don't have a quantified water right. So without quantification, it's hard to ask for protection because it's hard to draw the line to say, that's too far into my house. That is cutting through the exterior wall, everything. We don't have that boundary because we don't have a quantified right. Remember, Doug talked about the basic components of a right under the state system. It's to have a clear quantified right, and then you have that balancing point where if that right gets infringed upon, you have an effect and you have a right to protection from the state by the state system. Because Lummi doesn't have a quantified right, theoretically we do not have a right to protection from junior users. And that just does not comport with the concept of being the most senior user in the basin. So I just shared Lummi's goals. And then the other question I get a lot is, well, what happens if Lummi's water right does get quantified? Does that mean you, Diana Bob, will be sitting in ecology saying, yes, they get a permit, no, they don't get a permit? No, that's not it at all. There's no desire on behalf of the Lummi tribal government to micromanage the water rights that are not part of the Lummi share. And what Lummi's asking for is litigation where a federal court will quantify the Lummi water right. And then that means the rest of the water in the watershed is subject only to the continued management and enforcement authority of the Department of Ecology. So ecology already has authority to manage water rights in the state system. What would happen is there would be a recognition of the Lummi share, and then the balance would just be regulated just the same way as ecology currently regulates water rights in the basin. And so what would happen then is that water rights would need to be managed in a way for ecology to maintain that water necessary to meet the reserved in-stream flow right for fish. And then ecology just, allocates the water however necessary between the domestic, municipal, industrial, and commercial users in the basin. So Lummi would have no management authority, Lummi would have no veto, Lummi would have no say in what ecology does with the rest of the water. Lummi is really just looking for the Lummi quantified amount of water to stay in the river and the tributaries. And that's all I have. I do want to say there's a lot of information, including in 2011, we wrote a formal letter requesting the litigation to the United States, and that is all available on the Lummi Natural Resources water website. So please, if you have any questions or want any additional information, definitely check that website out. And then folks at Lummi Natural Resources staff can answer questions, and under some situations I can answer questions too, but I do represent Lummi and I can't give our litigation strategy or anything like that. Thanks.
Thank you, Diana. So we have been joined now by Bill Clark, who is a very experienced and very high-quality water lawyer here in Washington, represents an array of clients across the state. He also has been known to do a little lobbying now and then in Olympia. And Bill is going to be part of what will be primarily a Q&A session from now until 2:10. But we thought it'd be good to give Bill a couple of minutes to say a few words.
Sure. Thanks, Jay. Good afternoon, everyone. I have to observe that there are many conferences going on in Washington State today, but very few of them deal with issues going back into, before the Declaration of Independence and things like that. That's why water law is so much fun. Just to tag on to what Jay said earlier today and to start this session, the way I explain it to folks sometimes is that you are all facing, 21st century challenges, which are things like climate change and an export-related economy and 1 million more people moving to Puget Sound in the next 20 years. You have 21st century challenges. You have a water code that was written in the early and mid-20th century based on principles of the late 19th century. So water law spans these different centuries, and I think that provides a real challenge because the presentations today indicate the fundamentals of water law have not changed a whole lot, right? There's these concepts that date back to the mid-1800s. The statutes themselves haven't changed a whole lot, with some few exceptions. But I think the thing to talk about going forward is to not let these old confines of the water code be a box that you're stuck in, and use the aspects of the water code as a kind of stepping stone to do what you need to do here locally. So not to interrupt the flow of the presentations, why don't we just go back to you, Jay, and we can do questions from here.
Okay, thank you. So this is scheduled to be a roundtable, and we could sit here and talk to each other, but it seems like a better idea to talk with you and give you an opportunity to ask questions and make comments. If you don't have any of those, we'll then instead talk amongst ourselves. So who...
I suspect there's questions. Can I get a show of hands just so I know how many? There's going to be quite a few questions, so I would ask each of the people that is asking the question to be brief so we can try and get it to as many people as possible.
Okay, along with the treaty purpose for the reserved lands, is the assumption correct that a federal reserved water right depends on the amount of tribal land held in federal trust?
Sorry.
I think the answer to your question would depend upon a determination of the purpose of the reservation. So if the reservation's purpose was tied, for example, to agricultural use of the land, then the answer to your question would be absolutely yes. But in PIA. However, that's where the uncertainty comes in, because there can be more than one purpose for a reservation, and if the purposes of the reservation, they have to be principal purposes. If the purposes of the reservation include things like fisheries, then there's going to be an implied right of water for the fisheries as well as, and it has nothing to do with how much land that the tribe has.
I think the premise of your question is not entirely accurate. The reserve water right and the amount of the water right reserved by the treaty is completely unrelated to the amount of trust land that continues to exist on a reservation. So they are not exclusive to one another. So one does not inform the other in the quantification of the water right. What Michael's getting at is the purpose of the underlying reservation, but again, that is completely independent from the amount of trust land that exists within the exterior boundaries of a reservation. So it doesn't have a bearing based on all the case law that I've reviewed.
Other questions? There were many hands up. I'm going to go to the back of the room here.
Thank you.
You're not qualified. You can't ask that question.
This one's for Jay. Well, I'm curious about precedent or other case law in Washington that might be instructive based on Yakima experience. The Aquavella adjudication, Yakima Basin adjudication hasn't concluded, but the tribal rights at this point have been established, and you mentioned earlier time immemorial. So is that is that instructive for the situation up here? And are there other cases in Yakima? I'm thinking of Kittitas Reclamation District versus Sunnyside that recognized the tribe's time immemorial water rights. Are those outlying cases, or are those really establishing something that we should be looking at here?
Well, I'm going to let others weigh in on this who are practicing water law more consistently than I am now. I'm mostly a recovering water lawyer. But one thing that I may be wrong about this, but one thing that Diana, listening to your presentation, I thought there was a federal statute, the McCarran Amendment, that allowed for tribal rights to be quantified in the context of a general stream adjudication, not in the context of sort of a one-on-one lawsuit between parties, but in that special context of a general stream adjudication, which is what Aquavella is for the Yakima. Along with all the other claimants or water right holders in that case, the Yakima Nation was one of the claimants, and they were claiming both an on-reservation and in-stream flow right in that context, and those rights were confirmed, as I understand it, but in particular the in-stream flow rate at a level that the tribe, it was substantially lower than what the tribe was advocating for, and the court found that a congressional action, I think in the 30s, had diminished the right, and therefore found there was a right, but it was less than what the tribe expected. Now, as it has worked out in practice, as I understand it, there is a committee that's been formed in the Yakima Basin, SOAC, that involves state, federal, and tribal fish agencies that really work together on almost a day-to-day basis because it is a managed system with the reservoirs high in the basin. The feds own and operate most of those dams. They can really sort of control how much flow is released into the river on a very managed basis, and SOAC does that. The tribe's part of it. So I do think there's precedent from the Yakima Basin that in that one context of a general stream adjudication, a state court can quantify a tribal right, but it respected that right. It found that right did exist, just at a lower level than what the tribe expected.
So the McCarran Amendment under federal law does permit state courts to adjudicate some tribal water rights. However, what I was trying to avoid today was talking about the political underbelly of initiating a general stream adjudication in the state of Washington. The legislature can expressly curtail any efforts to do that the way that the revised Code of Washington is set up, and the method in which a general stream adjudication can potentially be initiated by the Attorney General's office. This situation is subject to a lot of particularized political intervention, that to the point where, yes, the Yakima Basin has been subject to a general stream adjudication. I think that case started before I was alive.
77.
Yep, 1980. And
I hate you.
and the Ecology and the AG's office has had for several years a goal of starting a similar stream adjudication in the Spokane Basin. Now, Spokane, I used to live in Spokane, and there's some real problems with water availability and competing uses there. It is a crisis there, yet our legislature cannot manage to allocate the funds right now to start that stream adjudication process. So the strategic approach that Lummi decided, about 12 years ago, was not to wait around for the legislature and the Attorney General and Ecology and all of those folks on the state side to get the ducks in the row to initiate a general stream adjudication and change the paradigm, which is really to protect Lummi's interests. We don't need to know exactly what's happening with everyone else's rights in the basin. You just need to know what Lummi's right is, segregate that from the rest of the rights in the water in the basin, and leave Ecology to do the job that Ecology is trained and professional at doing, and that is managing the state water rights. So a general stream adjudication, while there are some mechanisms under federal and combined with state law where tribal rights can be addressed, the political reality is that it's not a solution for a community that's looking for certainty in the near 50 years.
And I didn't mean to imply that I thought it was. I'm not questioning the tribe's strategic decision. And it would be an interesting question. While I'm betting that there are some folks in this room and outside this room that feel a little bit nervous about the tribe's right being quantified, given that it likely will be the most senior right in the basin, and there will likely be an in-stream flow component. It's interesting to contrast that with how would those same folks have felt if a general stream adjudication had been initiated and they'd all been named as defendants in a lawsuit. I think some would have welcomed that, some definitely wouldn't. So I'm not arguing about the choice of tactics, and given the 10-year effort to try to put something together, that wasn't my point. I was just remembering that there is one way to bring a tribal right into state court, but I'm not arguing it's necessarily better than what you've initiated. Bill?
Well, I was just going to say that I think, the question for the state would be, for the Department of Ecology and the Office of the Attorney General would be, if a federal adjudication is commenced, would that then force the state's hand? In essence, would the state then say, okay, if the tribal right is going to be adjudicated in federal court, would now be the time to commence a general stream adjudication in Superior Court, remove the case from federal court to state court, and have a complete adjudication? Or would the state stand by and allow the tribal rights to be adjudicated without touching any of the non-tribal rights? Because as Diana said, the idea of commencing more adjudications in state court is not popular in Olympia, in part because they're so costly, right? I mean, the legislature looks at it and they see the line item in ecology's budget and the Attorney General's budget for the Yakima adjudication, and what the legislature wants to spend money on is not legal fees, right? They want to spend money on projects like the one Jay referred to that actually put water in the stream, that actually get water to people. They're less inclined to be interested in supporting adjudications because they have to hire attorneys, as would, you know, the large municipal water right holders and everybody else. So I think the question would be, if the federal adjudication is commenced, does that force the state's hand to commence this general stream adjudication to remove it to state court with the attendant cost that would bring?
You couldn't take it out of federal court. What you would do is you'd have to ask the federal judge not to decide, to defer to the state court. So you see, the issue here is you could have two lawsuits, right? Two times the delay.
Good question here, then I'm going to go back to Jim Bucknell.
Thank you. My question is a geographic one. Thinking in terms of the whole Wairo 1, the Nooksack Basin watershed, you're talking about in-stream flow. Never been clear to me which streams are being talked about. Obviously the main trunk, the three main forks, but then you go lesser and lesser, smaller creeks and so forth. Are all of those subject to in-stream flow quantification, or is it just some parts of it?
Yeah, there are control points on the tributaries and the branches of the Nooksack River that are listed in the rule. So you got to look at the in-stream flow rule, see which streams are regulated.
Hey, Doug, let me interrupt. I want to make sure we're answering the question. Is your question directed at the tribal claim or how the state in-stream flows are established?
Both.
Okay, so Doug's answering for the state in-stream flow.
Right, so for each one of those reaches or tributaries, there are control points. And so if a tributary is closed to further surface withdrawals, that means any tributary, any branch, headwater of that stream, no surface water withdrawals would be allowed. And nor any groundwater withdrawals that would also further impair that stream.
And if it's not closed, would it be quantified for all the little creeks?
All right, so we have closed streams, we have streams that are seasonally closed. So in those, you can't get a water right if you need that water during the closure season, which is usually when there's less water available and more water needed. And there are other ones that are flow limited. So if a flow drops below a certain level, which is on the main stem of the Nooksack, you have to shut off if you're junior. That makes it tough for something like irrigation. But so.
And if I could, Jade's clarification gets at an important distinction. That is, we're using the term in-stream flow in a couple different ways. The in-stream flow adopted by Department of Ecology for the Nooksack Basin and many other basins in Washington State, that's an in-stream flow that's recognized under state law. The in-stream flow level is in essence a water right for that flow in the stream that has a priority date of the effective date of that regulation, right? That in-stream flow rule, let's say I think the Nooksack was adopted in 1985, so that in-stream flow level has a priority date of 1985. That in-stream flow level, let's just say that it's 500 CFS, that in-stream flow is not the tribal reserved in-stream flow right. In fact, I think in most cases, tribes around Washington have expressly said, well, they want ecology to adopt state regulatory in-stream flow levels and protect them, that those in-stream flow levels under state law do not result in a protection of the federal in-stream flow reserved right. So there's a difference between the in-stream flow adopted under regulations by ecology and the in-stream flow right that tribes have under their reserved rights.
I didn't get an answer to the geography question.
I will provide that.
Little Creek,
Yeah.
next to my friend's house, it's going to be regulated.
So Lummi's treaty right, just as the other tribes that executed a treaty with Isaac Stevens in 1854 and 1855, have a reserve right to take fish in usual and accustomed places and on their reservation. So if the water right is connected to the right to take fish in usual and accustomed grounds and stations and on the reservation, then the water right ought to be protected in the usual and accustomed places and on the reservation. So for the Lummi answer, the geography is anything that's Lummi's usual and accustomed place is where we'd want to protect the in-stream flow to support that treaty right.
So to make it real simple, under state law or federal law, the answer is yes, your friend's little stream in the backyard is going to be regulated.
Do we have time for some addition? Great, okay.
My question is, where there's a federal reserved in-stream flow right that's been established and quantified, does the tribe then have the latitude to take that water out of stream for consumptive use or to sell it to non-Indian parties for out-of-stream use?
That depends upon how those water rights were created. In almost all instances in which you've got in-stream flow rights established, and the Snake River Basin Adjudication Settlement is a good example, what you have is the terms in the settlement agreement providing for whether or not a tribe can market the water. The black letter rule going way back is tribes cannot market the water. Right? However, that is settlement dependent. It's dependent on each individual instance.
Other questions?
Given the history of treaties with Indians in this country or Native peoples and the government, and the broken promises and treaties that have occurred over several hundreds of years, this issue now of the fishing rights by the Lummi tribe seems that if they are given the rights that they were given a long time ago, and that goes through, does not that preclude the corporate rights of the coal terminal being built and infringing on the water usage that would preclude fishing rights by the Lummis in the Nooksack River?
The treaty right could potentially be affected by any industrial water user in the usual and accustomed places that Lummi relies on fish. And whether there's a settlement of this water right that Lummi's seeking for in-stream flow, and whether there's a new industrial development at Cherry Point, those are not entirely related or dependent upon one each other. However, Lummi does maintain an interest in both because it's related to the treaty right and the right to take fish and the desire for fish to be there for the purpose of fishing.
Could I just add one thing in response to your question? You're asking about the collision between the intent that was established in 1855 and the current world situation. And it's obvious by looking around that a lot of things have changed since 1855. There's development everywhere. How does it work together? Well, the answer is, again, you can find the answer in the Winans case when the court required those fish wheels to be removed. What it said is, there's a change that's happened. Tribes have not been divested of their rights. However, there has to be an accommodation. So in other words, what is envisioned is the evolution of society. On the one hand, tribal rights being preserved to the extent reflected in that accommodative situation. On the other hand, settlement happening. I mean, the quid pro quo in the treaties was tribes sell the land. Why did they sell the land? So it could be settled. So there's obviously a quid pro quo going on. That's why I mentioned when I talked about culverts, you look at whether or not there's been a state infringement on the right. whether the state has elected, in the Culver's Court's words, elected, chosen to do something that hurts fish, when it could have chosen to do something without hurting fish. So all these things about development and all that, has there been an accommodation? And if there's been an accommodation, okay. And if there hasn't been, then the tribal rights got to be vindicated. Hydropower is a good example. The Federal Power Act has a provision that says if you get federal license for a dam, you have to have fisheries mitigation. That's to accommodate the pre-existing fish use.
Doug, for Cherry Point, we would, if they wanted water, and if they, there's a couple ways they could go about it. If they decided to apply for a water right, we'd process that application through our process, or we might consult with them about whether that's a good way for them to go about it. And whether or not that water right, they got a permit for that water right, would depend a lot upon who they might impair, or if anyone. But they might also decide to purchase water, and I think there's probably been discussions about that already. They might want to purchase water from somebody else who has a right, that's a valid right. And so that's another route they could go.
So I have a different answer. I thought we heard earlier today that Gateway's already under contract with the PUD for the water. And so if the tribal right is established as per this petition, it will have a priority date of time immemorial. So it's going to be the most senior right in the basin. There will likely be an in-stream flow component, but we don't know what that's going to be. But it'll be established at a certain quantity. And what the effect of that will be that everybody's right in the basin is then going to be junior to that right. And it's going to be a function of math. Where is the PUD's right in that chain of priority? And as you meet the tribe's right, then you meet the next most senior right. You do those in order. They get completely satisfied in order until you get to the PUD. The question will be, will there be enough water for the PUD to honor that contract? And we don't know that because the tribe's right's not established yet. Now, if it turns out there isn't, then like Doug said, the Gateway will have some options to go look elsewhere. But if the PUD is affected, it's going to be a tough sled, I think. It's going to be impossible probably to get anything new from the same water source. And if there's anybody senior enough to go to, who knows? So I'm not trying to paint a big, ugly picture. It's just, I really have a lot of sympathy for the tribe because they've had the most senior right in the basin for a long time, and because it hasn't been quantified, it hasn't been protected by anybody, by the ecology or anybody else. It's pretty hard to protect a right that doesn't have a quantity established associated with it. And I don't blame them for wanting to have it quantified. But once they do, there is going to be a ripple through the community. And my comments earlier today about sort of taking control of your own destiny and figuring out a set of solutions that can meet a whole range of interests, there's nothing inconsistent. In fact, that becomes more important once the tribal right is established, because then there is going to be more scarcity. There is going to be a need for solutions for people, for the tribe, for all the interests across the basin, and it's entirely doable.
Yeah, and if I could just say in response, that is 1,000% correct. What you're hearing today in this panel, these rules, what is the law? What does it say? Well, you have to learn that so you can forget it. Because, to solve a problem, you can't solve it with these rules. If you've heard anything, you've heard that the rules aren't quite adequate to the task. Because we're all sitting here and we know that we don't want there to be no water for any uses in Whatcom County except fish flows. We know that. So now we got to decide to figure out a way to do it. And if in fact the threat is all or nothing, then maybe that's a goad, an incentive. And tomorrow I hope we're going to be talking about, well, let's look at some problems on the ground and how they might teach us about what we've perhaps been doing wrong the last 10 years.
The way that we might respond to such a request kind of depends on the timing, because, the GPT terminal, the process they're going through, we're going through with them and the county and the Corps of Engineers to get to the point, do an EIS, so we get to a point where the county can consider whether or not to issue them a permit to do that, will take years. Now, if that happens before we have a quantified treaty rights for in-stream flows, we're going to have to make some kind of a decision on that, and that decision might be affected by what happens after we go back to litigation or negotiation or however the treaty rights get quantified. So, it's fluid, it's speculative, it's hard to know, but these things all could take more years than I dare think about, but it just depends.
I was going to also just add that, the adjudication could be a triggering event, but it's not the kind of thing that other water users should just sit and watch. That is, I think, what you would want to do is use that to engage in what do you do when, as Jay said, the priority doctrine kicks in, right? The tribal right is first, and then the next one, and then the next one. That's going to really change things. And so how do you figure out when there's not enough water left at the very end, how do you reallocate that water, for example? How do you meet future demands? And don't find yourself constrained by this archaic water law we have. That is, the lesson from some other basins around the state is, if the law that applies generally statewide doesn't work here, given what's going on here, you can change the law, and the legislature will support that if you have a group of water users sticking together to do what they need to do locally.
So I'll finish and wrap it up by saying the famous jurist Mark Twain was quoted as saying, "If that's what the law says, then the law is an ass." Sometimes it is. We shouldn't feel constrained by it. This has been a really great panel. I really appreciate the comments here. I appreciate your great questions. We are done for now, I think. Do we have a break?
Yeah, we've got a 10-minute break, and I also want to thank you, Jay, for coming up, and I know you've got a